Dear our distinguished delegates, as assigned by the organizer, I would like to present new regulations on sanction for administrative violations in the IP law. My presentation today includes five main points. The first one is overview of Decree 46, 2024. Amending certain regulation of Decree 99 and also certain amendment and supplements on administrative violations, penalties, and remedial measures. First of all, I will go through overview of Decree 46, 2024, amending certain clause of Decree 99. So different from the EU, infringements of IP rights are handled by civic or criminal measure. In Vietnam is quite different. So for infringements of IP right in general and for industrial design in particular, it is handled by administrative procedure by competent authority. For example, custom authority, DMS, and according to a survey, more than 90% of the cases of infringement cases are handled by administrative measures, and this measure play a critical part in the Vietnamese IP law. And in relation to administrative sanction, Vietnam has a separate law to regulate infringements on IP right. So the in terms of administrative sanction for IP right, for example, objects of sanctions or procedures of sanctions. In addition to that, Decree 65/2023 also have certain clauses in regard to industrial property. And these amendments in the Decree 99 also need to ensure the consistency and following the IP law regulating administrative sanctions. So first of all, the purpose of issuing for this Decree 46 is to complete legal regulations on sanctioned administrative violations in IP and to ensure compliance with the law on IP as well as resolve difficulty and obstacles in practice and ensure the effectiveness and efficiency of enforcement of the laws on IP in particular and IP in general. So overview of this Decree 46, there are four articles. Article 1, amending and supplementing a number of articles of Decree 99 in 2013, and this can be considered as the major change. And Article 2 is adding, replacing, and canceling clauses, points, and articles of Decree number 99, 3 clauses. And Article 3 is responsibility for implementation, which include 2 clauses. So the first part will be amendment and supplement to general provisions. In terms of amendment scope, this decree regulates administrative sanctions in terms of the form, level, and remedial measure. Also, as the authority to receive the applications or process and to clarify the amendment scope. In addition to that, is also added in Clause 4, Article 1A to clearly define subject to administrative sanction, and which are branches, representative offices, and business locations of legal entity and organizations. And this will be supplementing the objects of sanction, which is branches and representative offices. The next amendment and supplement is form of suspensions. In Decree 99, there's only general regulation for suspension of business. However, in this revised law, there are 2 cases of suspension. Part partly suspensions or whole suspensions based on the level or the severity of the infringement. And in this decree, 46 also clarify the suspension of a product manufacturer, whether it is partly or in whole. This decree also removed difficulties in implementing and enforcing these articles. For example, destroying and dispersing the proof of infringement. And in reality, this regulation actually in the past led to many obstacles for authority to enforce it. So in this decree 46, there are certain supplements instead of forced recovery of the evidence, it is restored to their original conditions. In addition to that, it's also added the clause forced to return illegal profits obtained from administrative violations in cases where they are ground to determine illegal act. And the next part is Article 3A on applying measure to prevent and ensure the handling of administrative sanctions related to domain names, especially unfair competition. This is actually quite popular in Vietnam, and the level of complication is increasing. And in order to identify the infringements of domain name is quite difficult. For example, the objects or the subjects of infringements, locations, as well as measure to rectify the consequences and to ensure the effectiveness of handling infringements in domain names. So at the moment in Decree 99, there is no regulation to ensure the handlings of unfair competition related to domain names. And therefore, Decree 46 has added one measure, which is created the domain names and also regulate the responsibility of competent authority. For example, agency and personnel competent to handle administrative sanction may request the Ministry of Information and Communications and the domain name registrar to coordinate and provide professional opinions and maintain the status quo before taking measure. And the Ministry of Information and Communications will coordinate with agency and competent people to handle those violations. So the supplements of these measures are expected to enhance the effectiveness to resolve unfair competition. And the next part is amendment and supplement to administrative violation, penalties, and remedial measure. The first amendment and supplement is in Article 6 for transferring the right to use IP object without a license contract. So the IP law in 2016 saying that when transferring the right, it needs to be in written form, even though that in the law, but Decree 99 doesn't have any specific enforcement to implement these regulations. And that leads to difficulty and obstacles in handling these cases. Therefore, Decree 46 has supplement regulations on penalty on IP object without license. And it's also added remedial measure. So forced removal of infringing elements on goods and means of business for violations. In terms of penalty, the decree also supplementing in terms of industrial property representations, the amounts, fee, and charges related to procedures, information or dishonest informations, and also in terms of resolving disputes and handling violations of IP during that period. In addition to that, in terms of remedial measure, it also clearly separates two levels of sanction for individual and organization. So for individual, it will be depriving the violator of the right to use the IP representation services from 1 to 3 months. And it will also be depends on the level of violations. That suspension period will be increased. It can be from 2 to 3 months. So the separation between these two levels of sanction will be depend on the severity of the infringements in order to enhance the enforcement of the law. And also in this decree, it's removed all of the remedial measures. For example, forced to return the IP representation service practice certificate. The next amendment and supplement is a penalty for violations of sealing and temporary seizure of evidence and means, which clarify on evidence and proof in order to enhance the effectiveness on remedial measure. So for evidence which are already dispersed or destroyed, it's very difficult to handle the cases. It also clarify the act of dispersions or destruction will subject to inspection. It's also added remedial measure about forcible recovery of evidence and means of violation that have been altered, exchanged, or dispersed. The next part, this one is quite important in terms of penalty for layout design and industrial design, which is about the right to store for sale, display for sale. It didn't clarify whether it is store for sale or display for sale, and therefore it's make difficult for the authority to handle. And in Decree 46 is clarified that the store for sale of product will be handled differently. And according to Decree 99, there's a fine for a good in transit. Infringements of good in transit related to utility solutions or layout design. And in Decree 46, remove the clause C, forcible removal from the territory of goods in transit that infringe upon IP rights. In addition to that, is also added clause D, forced to pay compensations equivalent to the price of transferring the right to use the infringed inventions. So if there is no compensation when transferring the right to the layout design and invention, is also considered infringements of IP right. And Decree 46 also added the remedial measure for this act, forced removal, forced to pay compensations equivalent to the price of transferring within the corresponding scope and term. And next part is for trademarks and GI. So this is similar to patents and industrial design. It is also clarified for whether the product is stored for sale or for display for sale. And there's also added clause for remedial measures. In regards to counterfeit IP goods and counterfeit GI goods, Decree 46 added certain acts on GI counterfeit goods, which is act of offerings or displaying the goods. Decree 46 has clearly amended or supplemented remedial measure and stipulate that the goods in transit, if it is infringed related to patents and industrial design, for GI counterfeit goods, the act of infringement will be handled even if it's good in transit. Decree also added this remedial measure, which is forced removal of Vietnam from Vietnamese territory or forced to re-export of imported or transited goods. In regard to stamps or labels of products bearing counterfeit trademarks or GI or counterfeit GI goods. This is similar to counterfeit goods for stamp and labels. This will be handled even the goods is in transit. In regard to unfair competitions in the industrial property, the fine is increased in regard to state business secret from 50 million VND to 100 million VND. And in addition to that, the revised IP law in 2022 amended the unfair competition related to domain names, which is register or occupy the right to possess, use, or use a domain name, or take advantage of the domains with bad intentions. So this Decree 46 has amended certain clause to make sure that it is in accordance with the current IP law. And the next part is in terms of amendment on administrative sanctioning authority. The first one is supplement in Article 15 in terms of offering the goods and displaying the goods in domestic market. Or for custom, they will have the authority to sanctions in the following violations. In terms of transporting, storing, and displaying goods with counterfeit mark. In Clause 5, Article 20 also has been cancelled to ensure clear principle of the regulations. And also Article 21A about authority to make records of administrative violations. So in addition to people with authority to sanctions, there will be people of the people public securities and other relevant agency who can perform official duties and tasks. So next is amendment and supplement to handle violations. First one is amending and supplementing the name of Chapter 4 in order to be accordant with the current regulation. Also, amendment and supplement in Clause 2 in terms of verifying the administrative violations infringing on public property rights. For example, requirement for handling act infringements or results of inspection by agency competent to handle the violations, or information provided by individual and organization that detects the act of infringements. And this supplement is expected to create a premises for enhancing the effectiveness of the current law. In addition to that, this decree also cancel provisions in Article 24 regarding application for handling violations. In regard to providing evidence and proof, And in Article 24 and 26, it is cancelled because in Article 25 there are relevant contents which are duplicated, and the law on administrative violations has cancelled these two articles to be in accordance with the current practice. Also, Article 28 also cancel the negotiation between the sale negotiation between two parties to handle the infringements. So, if there's our confirmation of infringements, the government authority must resolve the case, and the previous regulation, which is handled between two parties voluntarily, is no longer applied. And the next one is the order or procedures of handling dispute related to domain names and businesses. This regulation actually is mandated in the regulations of the Ministries of Science and Technology, and also the circular between from the Department of Information. And these regulations initially are in these two circular, and after being enforcement for a certain time, there are the need for changing or amending to transfer this to other measures. And also this decree has amended certain regulations on sanctions administrative for forced removal, and there is no mechanisms in cases when organization and individual doesn't implement the sanctions resort, and in that case the authority can providing for enforcement of remedial measure, as well as to supplementing regulations for the goods to be taken out of Vietnamese territories. And another content that I would like to mention is regulation in regard to the specializations infringement specialization inspections. And during the process of building Decree 46, there are opinions and feedback that this Decree 46 needs to include certain regulation to clarify the level of fine of inspector in terms of infringements on IP right. However, in order to ensure the timeline of the decree, related regulations related to specialized inspections has not been included in the Decree 46, and later other regulations related to this point will be added into a decree amended and supplementing regulations of specialized inspection in all of the industry, and this will be built by relevant authorities in the coming times, and there will be a clear amendment and supplements on the level of fine as well as the procedures and level of authority. And that's some information that I want to provide to our participant today. And this is one of the new things as well. So the fact of adding supplementing authority of sanction handlings is also an important topic. So those are these are the end of my presentation. If there is any further questions, please let me know, and then we can discuss. Thank you very much.